Copy.
Right.
What?
Hey, what the heck is...
Copy. Copy. Go right. To the right. Right.
It's that law that's the problem.
You know the law.
That stupid law.
Hey, what the heck is...
Copy.
Right? I'll tell you.
Copy.
Right is
permanently fixed.
The original
work.
What?
Permanently fixed.
The original
Work
In
some form that can be seen or heard.
Now listen, this is important. Only the
Copy.
Right.
Owner.
plus the
right
to
use. There.
work.
If you had worked to collate 7,700 telephone listings for a telephone directory, and someone else came along and simply copied your listings for their own telephone directory, how would you feel? Well, this is the case of Feist Publications Incorporated and Rural Telephone Service Company. The defendant Rural was a certified public provider of telephone services to various communities in northwest Kansas, and under state legislation was required to annually publish telephone directories with both white and yellow pages. The data for these directories was obtained from subscribers who had to provide their names and addresses in order to obtain telephone services. Rural distributed their directory free of charge to subscribers, but generate revenue from selling advertisements for their yellow pages. The plaintiff, Feist, was a large publishing company specializing in area-wide telephone directories. The Feist directory was much larger than that of Rural, covering 11 different telephone service areas and included almost 47,000 white pages listings. Like the Rural directory, distribution was free of charge, but Feist and Rural were direct competitors for the yellow pages advertising. As Feist had no access to subscriber information, it sought permission from the 11 telephone companies to use their white pages listings. All agreed except Rural. Rural took action because Feist used their listings anyway. In the first instance, Rural successfully sued for copyright infringements in the district court. This judgment was later affirmed in the Court of Appeals. Subsequently, Feist sought to have the decision quashed by the U.S. Supreme Court. The U.S. Supreme Court unanimously reversed the Court of Appeals decision, finding that the selection, coordination, and arrangement of Rural's white pages did not satisfy the minimum standards of originality for copyright protection in the U.S. So what is an original work in the U.S.? An original work must 1. Be independently created by the author, and 2. The work must possess at least some minimal degree of creativity. In Feist and Rural, Justice O'Connor provided the lead judgment and emphasized that this case centers around the interaction between two well-established propositions, namely, facts on their own are not copyrightable, and factual compilations are copyrightable. What becomes apparent from this is that under U.S. law, facts and factual compilations may be treated quite differently. While facts do not owe their origin to an act of authorship, factual compilations, however, may be copyrightable on the basis of how they are presented. So for an original work, the main focus should be on the manner in which the collected facts have been selected, coordinated, and arranged. From this flows that no copyright protection exists where the compiler adds no written expression, but lets the facts speak for themselves. Considering this in the case of Feist and Rural, it becomes apparent that Rural may have compiled the facts, however, has simply used raw data, and is expressed by Justice O'Connor that 100 uncopyrightable facts do not magically change their status when gathered together in one place. So one might ask the question, how can it be fair that all the labor of the compiler can potentially be used and at least indirectly be commercially exploited by anyone without any liability to compensate the creator for their hard work? The answer to this question lies in the primary objective of copyright as manifested in the writings and discoveries power contained in Article 1, Section 8, Clause 8 of the US Constitution, which is not to reward the labor of the authors, but to promote the progress and science of useful arts.